It's always quite neat when a subscriber pops up on the page while you're going through and doing these things. That makes me smile. But unfortunately, it has that person's name, which is a bit of a worry. All right, let's do this. Live now. Simple. Ultra-Vires. Sometimes you see the word simple, sometimes you see it referred to as narrow. Ultra-Vires. Okay, so kick this off. Starting with the phrase Ultra-Vires. Ultra means outside and Vires means power. So it is things to do that are outside of the power. And in this case, it's outside of the statutory power of the decision maker. That's really what we're looking at. Whether decisions have been made that go beyond what the statute gives them. Parliament giveth a certain amount of power, and Parliament, hopefully, intends to carefully map out what the scope of that power is, to some extent. But Parliament can't determine things down to the absolute minutiae of everyday life of all of the branches of the executive arm of government. They cannot determine, oh, this person in the tax office needs a calculator today. We need to pass an act of parliament to do that. No, they can't. You've got to give the executive power to go through and do things, and they make discretionary calls about stuff. And so here, when we're thinking of this Ultra-Vires, well, this also does apply in terms of common law stuff. Not too worried about that at this stage. We are concerned about statutory frameworks, where you've got a minister and a stat framework, so I don't know, the Great Barrier Reef legislation, or the Passports Act. You know, there's a minister in charge of this statutory regime, and that minister, that person, can have many portfolios. They have many statutory frameworks that they are the head person to, but when we, as a Minister of Lawyers, are looking at it, we're looking at one particular statute, and we're looking at the minister at the top of that, and that minister is going to be given discretionary power to do stuff. One of the things to note about this discretionary power to do stuff, a really important one, is the ability to pass regulations, delegated legislation, delegated instruments, because there's this is an area where there's a lot of scope for you guys, with your newfound superpowers in administrative law, to be able to hold people accountable. So there's the aspects of doing that falls under this branch of what we call simple Ultra-Vires, stuff which is outside the power given to that executive decision maker by Parliament. And so that's the stuff we're going to look at today. Now, I'd mentioned that there are, in terms of grounds of judicial review, last week we looked at natural justice and prejudice. That's just a big one. That's one big topic. This is a collection of a small collection of things that are expressed in pretty simple language. The idea of simple Ultra-Vires, often the rules just say in the ADJR and the JRA, the decision maker has acted outside the scope of their power. It's expressed really simply, but there's a little bit more analysis to that in terms of the looking at the power that's given to them and how they've gone and actually implemented it. And then next week, we're going to look at stuff in terms of things like unreasonableness, so that rather than the scope of the power, we're looking at the quality of what the decision that's been made is actually done, looking at that in relation to the legislative framework. So, you'll see the word simple, Ultra-Vires. That's the bit where I'm talking about moving away from whatever the power that's given to it under the instrument. We also make a distinction here between one sort of special category of Ultra-Vires, which we call procedural. And that's because different judges and different theorists sometimes put that under the, I guess, the broad category we're going to do next week, but others also put it under the simple one as well. That idea that how and where there are particular steps that need to be taken under a particular legislative instrument haven't been followed. And so we have to look at that in terms of the procedural aspect, because sometimes it just doesn't matter. The executive decision maker has gone through, done a bunch of steps that Parliament has said, you've got to follow all of these steps, and they didn't follow it to the letter of the law, Sometimes that matters, sometimes it doesn't. And we'll analyze that under this category of procedural ultra vires, which, again, sometimes they include it into this broad category, the stuff we're going to do next week. Sometimes they include it in the simple category. In other words, it's not strictly following legislation. And sometimes you just analyze it separate. We look at simple ultra vires, broad ultra vires, and procedural is somewhere in the middle. Okay. I think in terms of the slides, I've used the federal legislation, which is kind of annoying because your chute uses the state ones. So just make note here. The definition of this is pretty straightforward. It's where decision makers have been given power by statute, and then decision makers gone and made a decision, and it turns out the statute actually didn't give them the power to do that. In other words, they didn't have jurisdiction to go through and make that particular decision or in that particular way. That's what this is looking at. It's to do with the scope of their power. And we use the phrase ultra vires, by the way, in a variety of situations outside of administrative law. The doctrine of ultra vires comes up in agency law, for those that have done the personal property, and I think Chris teaches it these days, used to be Tom's subject. Agency law, that idea of giving somebody the power to go and contract on your behalf, it comes up there. It comes up with powers of appointment and trusts. Maddie knows all about that. Yeah, sweet. It comes up in situations where there is a framework of some sort and a person's gone outside of that framework. It's a common law principle. Okay. And those are the relevant sections, by the way, that you go through and follow. So that if you're going through and answering this, and I can guarantee you this is an examinable set of material. This is examinable in the exam. The stuff in the test goes up to and including natural justice. So from this point onwards, it's not in the test. I'll confirm that in the cheats next week when we do our test prep. But those are the sections. There's only a handful of them, only a couple of them in each of the acts. Just note that the Queensland one has it in 2 different spots, which is kind of annoying. And when you're going and prepping this sort of material, after you guys have done your tests, prepping for the exam essentially, just make note it's helpful to put the citations for both of them just next to each other. You just in the exam, you just pick the one you need to use to cite that. Okay, so that's the simple stuff. The procedural stuff, which again I'll talk about today because it's a little bit. It is actually a relatively large fraction of this lecture, this material today, but it's a very large fraction of your assessment. This idea of having and looking at procedures that Parliament has said you've got to go through and do this, this, and this, and the decision maker hasn't done this or hasn't followed them strictly, and you guys have to put your admin law hats on and work out whether that matters or not, whether that's going to give rise to a remedy under the JRA or the AGJR, because sometimes procedures matter, and sometimes they don't. And so that's the sort of analysis that we're going to be going through and looking at. And the next slide is really relevant to the stuff next week, because the broad ultra vires stuff next week has got heaps of different ways, many, many, many little things that you can go through and try and seek some sort of remedy in administrative law. And generally they're harder. One of the things about the simple, this narrow ultra vires is that it's usually easier to go through and prove, and courts are much happier to go through and do it because separation of powers, where Parliament giveth some power to an executive decision maker and they exceed that power, courts are very, very quick to say, oi, don't do that. Whereas with the broad stuff, it's trickier because things require a lot more contextual analysis. And the courts don't want to jump into the shoes of the decision maker readily. And so I wouldn't probably write those down, or we'll revisit those next week. So, and kind of reiterated that in the next slide. Just make note that there can be a bit of a gap in terms of the way this is expressed in textbooks. Unfortunately, administrative law is an area where people like to hear their own voices. And they will have their own voices heard because they'll express things in different ways. And they will go through and have opinion about how things ought to be categorized. And they, I guess, I have my own very sort of robot-like brain that comes from a lot of my experience in terms of doing philosophy and being a software developer. And so how I go and categorize these things in my brain can be very mechanical. And you'll find that when you read other texts, they will describe stuff with many more words and in much more context. And I'm not saying one is better or worse, but it's something you need to be aware of in this area, that when I'm explaining things here, you will find, I guarantee you this, if you listen to Peter's lecture recordings or you listen to Jamie's, he does little screencasts that are all available on Blackboard. These things are going to be explained in different ways. And they're going to be explained in different ways because we're different people looking at these rules and expressing them using different language. And they're going to be expressed differently in different textbooks as well. So just leave that in the back of your mind. I'm trying to categorize it according to my brain. Other theorists might do it slightly differently. So that I just have to leave you guys with that little bit of ambiguity and make you just aware of that. It's not hard and fast. Don't get me wrong. The ADJR and the JRA are written like that, but how you go and conceptualize those in your mind in terms of those areas really doesn't matter. Just make note that it matters a little bit for me because I have to organize them topics for teaching you guys. That's why natural justice is 1 week. We're doing the procedural and the narrow stuff this week, and we're doing the broad ones next week. And so just make note, again, slide there, the narrow stuff is to do with exceeding powers. Whether it is a power given, person's gone outside it. That's reasonably straightforward. The stuff next week is to do with irrationality, abuse of power, and their lack of using the powers that are given to them. That can either be through doing things at the behest of others or not doing things when they're supposed to. So it's that abdication of responsibility. That falls under the broad category. We'll talk about that next week. Righto. One of the nice things about this area is that it has a little bit of the ye old areas of law where you're going back and looking at the interaction between the courts, the executive arm of government, and Parliament. And some of these cases are old because this doctrine of the separation of powers didn't just magically pop out of into existence at any particular point in time. Now, you guys, did I teach any of you guys for LA 101? I don't think I did. It's been a few years since I've taught it. And those that had the utter misfortune of having me in that would have me raving on about the history aspect of things. And I literally start with the anthropological start of humanity and people leaving Africa, moving it towards all of these centers of civilization and the advancement of technology and law, all the way up to the what happened in 1066. What happened in 1066? Bill, good old Bill. He has the biggest sword in the land. He arrives in the land of England and says, I am now your king. Oh, sure, he claimed some ancient right of ancestry, and he had some cousin of that. But essentially, he had the army, he rocked up, and everyone else in that land is now subject to him. And that's the sort of classic period in time where we look at, when we're looking at the English and then later the British sort of common law system. Even though that's not the term we use for time immemorial. You ever see that phrase, time immemorial? It actually has a technical legal meaning fixed by statute. It's the year 1189. So if you see that phrase, time immemorial. But this can start in 1066. And at that point in time, William the Conqueror is the absolute undivided sovereign. He controls the army. He is the head of the executive, we might say. But the other two branches of law don't even exist yet. And he did essentially start to create them, kind of. In that if you're the king, you've got the army, right? You can't be in all places at once. So he got a bunch of his mates and said, all right, I'm going to let you sort out Northumberland, you can sort out Wales, you can sort out Lancashire, and you can have Yorkshire. And we'll just build a wall. We'll just build a wall. The Romans did that. We'll just build a wall and keep those dirty northern redheads out. Very Game of Thrones. And those were called the barons. And the idea was the collection of barons was referred to as the parliament. This was not parliament as we think of it now. This is the collection of essentially those that the king has directly appointed and given authority to do things in the land. But they still owe fealty to him. He still has the army. Also, before 1066, people lived in the British Isles, and they had their own systems of laws. They had their own rules, local customs and stuff. And so what William also did was to send around a bunch of his well-educated, usually clergy-type mates, around the land to say what the king's law was, to make it common across all of his realm. And the judges reported directly to the king. They are saying what the king's law was, making it common. And so that's the expression, a common law. It's the king's law. Now, both of those two things, this idea of the parliament and the judges, they are not independent of the king. Quite the opposite. They are doing his will, his bidding. Okay, so we think about the separation of powers as, these things are separate and distinct, that sort of American style. Oh, no. That didn't start like that. What happened, though? In 1215, something happened. What happened in 1215? So, nice. 1215. Well, we actually celebrated the 800-year anniversary a couple of years back. The Magna Carta, the Great Charter. Tony Abbott was our Prime Minister back in 2015, and he's referring to the idea of shirt fronting. I'm going to shirt front Vladimir Putin. But essentially that's what happened. They had a king by the name of John, and it's by no coincidence that we have never had a king of England or Great Britain called John ever again, despite it being a very common name. Why? Because John was a terrible king, raised taxes, didn't look after the kingdom. The parliament came together, shirt fronted him. This is pretty brave. You appreciate it. This is your boss that you're shirt fronting. Made him sign a document that says no free man shall be, free man, literally free man, man with land, shall be arbitrarily detained. And that's a starting point to things like the writ of habeas corpus, in terms of that's one of those key remedies that we have in administrative law. No free man shall be detained. And you want to do stuff, you want to raise taxes, you want to do things, you've got to call the parliament together. And so this is the starting point. It didn't happen through us waking up one day and determining that such things, we need to have the rights of person kind. No. Most of you have seen the Game of Thrones finale. Most of you. And there's that point where Lord Aaron, they're talking about, Sam pipes up and says, why don't we give everybody the right to vote? And they all laugh at him. Suppose we should give our horses the right to vote too. Don't be silly. And that's right. That's essentially it. It's that idea that this stuff didn't come around. This idea of giving black people the vote, people without land the vote, giving women the vote. This was just alien for like hundreds and hundreds of years. And I'm talking like many, many centuries. And so this carried on. The parliament now existed, and it started to have its own rules and conventions, and the courts developed their own systems of rules as well. And you had the two court systems too, the courts of chancery, which was run by priests, and the courts of common law, both of which, this one were kind of more responsive to the clergy, the heads of the clergy. And who was the head of the clergy at that time? Who was the head of the clergy in between 1215 and the reign of Henry VIII. Who was the boss for all of the priests in the land of England? It was the Pope. The idea of Protestantism didn't come until a long time later. Martin Luther and good old Henry VIII, who didn't want to do anything with the priest. He wanted all of the priest's land, and because they would have this concept of the use, which was a trust. And so he tried to outlaw trusts, by the way. Did you know this? He tried to outlaw trusts. Didn't work very well, because the priests who were the courts of chancery just worked around them. We'll just make a trust upon a trust. They sort of gave up after that. Anyway, this developed slowly because what you find is that you have good kings and you have bad kings. And queens, we have the occasional queen here and there. And things were going around swimmingly until we had a bad king by the name of Charles. And Charles got everybody kind of offside. And in particular, a bunch of parliamentarians were sufficiently emboldened to grab him and do what? What happened to Charles? Charles II, I think it was. He lost his head. England had a civil war between Parliament and the Crown. Who won? Now let's put it to the vote. Did Parliament win? Or did the King win? No, the Crown lost. 9 years of civil war, and they lost. And so Parliament won, and a man by the name of Oliver Cromwell, who was by all accounts a very powerful individual, and everybody was scared of him. And so you would think, after the civil war is won by Parliament, it's all going to be good, right? Everything's going to be grand and wonderful, and we're all going to have rights and freedoms. Wrong. Cromwell was a Puritan, so he banned all of the fun stuff. No more drinking, no more dancing, no more singing, no more pretty stained glass windows in your churches, none of that rubbish. Life is going to be harsh, life is going to be difficult, you are going to work and you're not going to enjoy it. That's pretty much what happened. And so after Cromwell died, remember Cromwell, after overthrowing this terrible institution that is the monarchy, who does he appoint as his successor afterwards? His son. So his own son, who was not as powerful, not as scary, and quickly got shirt-fronted and replaced by somebody else. Who did the parliamentarians choose to replace Richard Cromwell with? The son of the king who got his head chopped off. So we talk about the Restoration. England was a republic for 9 years, and after Cromwell died, they restored the son of the king. And that was all fun and good, because he was Charles the Merry, and he restored drinking and dancing and fun stuff, and that was all fine and good. Everyone got to be happy again, because let's face it, England's not particularly... it can be something of a miserable place at times. Weather's not particularly great. What else is there to do? And after he was looking a bit sickly, his brother took over, James, and there was one very important problem with James. And this may not seem like a problem, but it was a real problem in England at the time. James was Catholic. And that was going to be a real problem. And so he got shirt-fronted. A lot of shirt-fronting here. What did they do? They found his niece, who was married to a Dutch royal. So William and Mary. They got sent a letter because some again, very bold parliamentarians, you're essentially committing high treason by shirt-fronting the king. They got together, sent them a letter, say, hey, you want to come and be King and Queen of England? If you do, it's just like, yeah. If you do, we've got some conditions for you. And those conditions, mapped out in a document, that further limited the absolute power of the monarchy to do stuff. And we call that document, in the year 1689, the Bill of Rights. Again, it's not the Bill of Rights as we would think it now, giving individual powers to people. It is, however, limiting the absolute power of the monarch to do stuff. Okay, these things limit the absolute power to do stuff. And I'm sorry about this little history lesson and such things, but it's really important to note that this clean-ish separation of powers that we have took a really long time to go through and do. Really, really, really long time. And you look at places where they don't have this, and one particularly powerful East Asian nation that is the world's manufacturing superpower doesn't have this, and it is very, very bad for the future of the world. I'm going to leave it at that, lest people come knocking on my door. Okay. All right, Antic and Carrington. Again, these cases are old. These cases are old, and they talk about this this justification. This justification of powers. They have to come from somewhere. You have to go and look at what the law is to determine whether a particular decision maker actually has the power to do so. So, some of these cases, by the way, overlap with stuff you'll do with Salome for those that are doing constitutional law. You're going to definitely have a bunch of these. Okay, I really like this phrase. I didn't write these slides, but I do like them because they delve into the constitutional aspect of stuff, and they can be a little bit more interesting than some of the quite dry things that come up in administrative law. And that's this idea that each is equal before the law, including the executive arm of government. What do we call that principle? What's the principle that each is equal before the law, including the executive arm of government? Celine? You know this. It's the rule of law. Now you know. Sure, that's... And so that's... and it's a really important thing. We accept and we essentially give our personal sovereignty over to the sovereign, which is essentially those three arms of government. We give our personal sovereignty over to them. They, in turn, have their own internal rules and controls that we recognise and we respect. They recognise and they respect. This is what we call the social contract. If we didn't recognise and respect that, there would be revolution. If the executive arm of government completely ignored the Australian Constitution and just did whatever they want and ignored what the courts did and ignored everything, we, the citizenry, in theory, would rise up against that. Okay, Clough and Leahy. Clough? I think it's Clough. Okay. This is expressed in real broad terms because they are going through and looking at the very nature of executive power under Section 61 of the Constitution here. And they re-examined this, by the way, in Williams. Williams was the chaplaincy case. Again, you may have done this in constitutional law. The federal government in Williams had a system of grants for school chaplaincies, and a guy, legal academic of course, from Toowoomba, raised the issue that I don't think the executive arm of government's allowed to actually do that, are they? And the reason why it was problematic, if you look at the year, and this took a little while to actually go before the court, what happened in the 2010 election? Who voted in the 2010 election? Oh, wow. Oh, there's only one person. I didn't vote, and I wasn't a citizen at that stage. Okay. Does anyone remember a person called Julia Gillard? Does that ring a bell, particularly to female budding lawyers amongst us? There was a woman called Julia Gillard who knifed poor old Kevin in the back. And they went to the 2010 election. And what happened? Something happened very unusual in Australian parliamentary election results. The minority government was a hung parliament. They had an even number of opposition and government seats, which is a real problem, particularly as you've got to allocate a speaker as well. So, as a result, the Gillard government couldn't guarantee that they could pass legislation. You could see how this could be something of a problem in our Westminster system. They couldn't guarantee, if they had a particular piece of legislation, that it would get up, because they had to ask some of the other MPs, Bob Catter, Tony, not Oakenshield, no, that's the dwarf in The Hobbit. Tony Oaken, I can't remember his name. Tony Windsor. Windsor, Oakenshot, or something like that. There were three rural, I'll loosely say independent MPs. They sort of had their own parties. And I think there was a Greens one as well, Adam Bant or something like that. Which one? It might be as well. I'm not sure, but there were four or six. There was between 4 and 6 of them, who the government at the time had to go and ask nicely if they wanted to pass legislation. All right. So what that meant at the time is that the executive government was trying to use Section 61, their discretionary power given to them in the Australian Constitution to do stuff, all over the show. They were saying, we're the executive arm of government, we're going to be able to do this, we're going to do this, and we're going to do this. And people put their hands up and said, no. Some things, incidental and core to your government function, the declaring of war or entering into treaties, sure, that stuff which falls under Section 61. Other things, though, you have to go through and actually pass things through Parliament. They require a statutory framework in order to do. You don't get discretionary power to do that. And so one of those things was the school chaplaincy program. Because it turns out the federal Parliament does have power to give money to the states for essentially religious purposes. The restriction in terms of religious freedoms in the Australian Constitution is interpreted very, very narrowly. It just says something like the federal government can't create or sustain or prefer, I think that's what it is, a particular religion. It doesn't have other restrictions. It certainly doesn't stop them from giving money towards religious-related education things, school chaplaincy programs. And so the Parliament can do that, but the executive certainly can't without passing legislation. That's just this core, and it's important from our purposes here, that's just a core function. The executive can't just do whatever the heck they like. They have to go, put that into a stat framework. That then gives them the power to go through and do stuff. Okay. Ruddock Vitalis, that's the Tampa case. That's the case involving the boat and the executive, again, trying to do executive calls. We want to turn back the boats. And the High Court said, no. Look, and a lot of these cases come up like this in admin law. It goes to the High Court. The Commonwealth loses. Usually the High Court says, look, the reason you've lost is usually a technical grounds. If you went back and passed things through Parliament this way, this way, and this way, this would be fine. But you didn't, so we're going to have to grant the writ of certiorari. And usually you'd go through and pass that legislation. But of course they couldn't do that in 2010 because some of these things they weren't going to be able to guarantee they could pass through. And we think that as being this, this great hamstrung government of our age, but appreciate that in the US, this happens all the time. It happens all the time because their Congress and their Senate can be held by different parties at different times. Here we have a Senate, again, which can have difficulty passing things through. But the idea of having coalition governments, this is commonplace. It's a common thing in many nations in Europe, in Canada, and certainly in New Zealand after 1993, where we changed our voting system. Okay, and Hayden's case is just very funny, so I'm going to talk about that in a little bit more depth because it's just funny. This is a good example of this idea of executive power gone mad, gone absolutely mad. So I'm going to tell you a little bit about this, and again, Justice Brennan goes through the history of the power of the king in the English legal system. But a couple of things to note. So you might remember this. It's going back a bit. 1981 in Victoria. Some bureaucrats got together and decided they would do a training exercise. Now, I don't know what was going through the mind of the HR manager who signed this off. Whenever I go through this case and I look at it, I'm like, who thought this was a good idea? Because I'm not making these facts up. So, they wanted to do a live training exercise, all right, for a hostage situation. Okay, seems okay, pretty reasonable training. It was the what did we call it? ASIO was part of it, but is it ASIS? I think it's called ASIS, is the Security Intelligence Service. The dudes who you don't know their identities, and they're allowed all sorts of cool toys. And they got together some people from ASIS, people from ASIO, and people from the Federal Police, and some army. So it was actually a multi-department thing, but it was run by ASIS, and some civilians as well. I think it were like 10 or 12 people. All right, so I want to do this live hostage situation. So we need to get some people to be hostages, sure. And we need to make it authentic. So what they did, they got real assault rifles, like real assault. They did use blanks, but they got essentially actual ammunition and assault rifles and all of the kits that you need to do that. And they booked a hotel in like Collins Street in Victoria. No, it was Elizabeth Street. So one of those very, very, very central areas. They booked a hotel, booked a floor or several rooms on a floor, and they didn't want their identities to be shown, so they went down to the local 7-Eleven and got little like animal masks. They've got, assault rifles, people shooting, because they're shooting blanks, but they're shooting. They've got hostages tied up pretending to be hostages, and they've got those machines used for bashing doors down, all right? And they didn't tell the hotel, they just booked some rooms. And so you've got these people doing this live exercise, shooting, bashing doors down, wearing animal masks, and full, the black sniper rifle kit. And so they're doing this, and of course, people in the hotel are freaking out. So they call the manager. The manager goes upstairs, and they go, "Oh, no, you can't be here." Grabs the manager, shirt fronts, takes them back down the lift, all right, and then goes back up, said, "Okay, time to go." And so they literally go with their assault rifles and these captured hostages to the little vans they have waiting outside, walking through the dining room, and they come outside to jump in their vans, and the Victorian police arrest them all. Okay, and of course, the first thing to do is now take the mask off and say, "Oh, no, you can't arrest us." Showed the paperwork. We are working for ISIS. We're working for ISIS. And so this went all the way to the High Court. And I just laugh the quote there by my favourite High Court judge. It was Justice's then was Sir Anthony Mason. This reminded him, it was so surreal, it reminded him of a law school moot written about the adventures of Maxwell Smart, which probably doesn't mean much to anybody other than Ewan, but this comical spy series from the 1960s. It was outrageously dumb that the people involved in this operation who had gone through, wrecked this hotel room, had assault rifles and were shooting blanks with their identities concealed, grabbing hotel staff and kicking them out, and then were just trying to run off into the distance, then showing a piece of paper that says, "Oh, this is our training exercise, we can do this." No, turns out you aren't actually immune to the criminal laws of the Commonwealth of Australia and the state of Victoria. And that's what the High Court said. And the fact that they thought that this was the case was baffling. Absolutely baffling that they ended up having to go to the High Court for people to say, following orders from a superior officer is not going to grant you any immunity from the laws of the land. That's just fundamentally not how this works. This is Jamie Fallow's research area. This idea of following others who ostensibly have authority isn't going to protect you. When I came to Australia, I thought the best thing on television were these guys called The Chaser. And they had a show once when they had don't get this right, the G7 or G8 meetings were here or something like that. It was, I think Howard was still Prime Minister at the time. And they decided, as part of their skit, their TV gag, was to get a limousine and to get runners like JFK, the runners with people with the earpieces and the dark glasses, running along the car next to it, and they drove this limousine into this secure area, somehow got through all the security, and then chase and then get out. One of them's dressed like Osama bin Laden, and they get out of the thing, they pretend to have a big argument about stuff, and then they all get arrested. And they all got criminal convictions for doing it. There's no fundamental excuse that you're doing this as a parody. The laws of the state of New South Wales in that case, and of the Commonwealth of Australia still apply. You can't contract out of it, and Parliament can expressly go through and give you power to do stuff, but it has to do it in clear, unambiguous terms. By default, you don't. Okay, so that statement at the top of that slide essentially encapsulates what I'm trying to get at. That doing stuff, executive doing stuff, administrative action that doesn't fall within statute is going to be ultra vires. That is going to give a person the right to seek a remedy under the ADJR or the JRA. If you do stuff beyond the scope of your power, you give the person the right to rock up to court and seek a remedy. But things that aren't a direct breach of a particular statute, so things that happen consequentially or incidentally to a particular statutory power, aren't going to be ultra vires. And so an example of that is perhaps to do with contract law. So that if you were to go and do something which is outside the scope of your power, and you engaged into a whole bunch of contracts, and again, I'm thinking in a government ministry, exceeding its power, enter into contracts. All right, you can't turn around and argue all of those contracts are going to be void just because you've exceeded the scope of your powers. That's not going to fly. That aspect of it, stuff which is incidental to doing stuff which may be outside the scope of powers, it's not usually going to be held ultra vires, and so certainly not the subject of review. Okay, now, the specific examples that you guys are going to be looking at, because they're going to be in your assessment, is to do with delegated instruments and delegated legislation. I don't know whether we should take an early break now. In fact, I think we might. We'll take an early break, even though I know we've only been going for like 40 odd minutes. This lecture's probably going to be a little bit short. We'll take an early break, and we're going to come back and talk about delegated legislation in 10 minutes' time. I think that's probably an appropriate place to stop. Yep, come back in 10 minutes. Delegated instruments. Now, you guys are aware, or maybe you're not aware, how delegated instruments work. And the idea is that you have a high-level statute, so for example the Townsville City Council Act or the James Cook University Act, where the Act will say usually things like the Governor in Council may make regulations under this Act. The Governor and Council may make regulations under this Act. Does the Governor actually do anything in regards to this? Well, usually they sign the piece of paper. What does the Governor or the Governor General in the federal sense do? They sign stuff. Occasionally, they'll step into stuff like Gough Whitlam found out in the mid-70s, but that is exceedingly rare. We have a convention that the Governor or the Governor General doesn't do stuff other than sign it. Essentially, it's putting a stamp of approval on instruments, and the Governor General or the Governor for the Queensland's regulations don't usually check it over. They're not looking at the underlying legal stuff. That is the domain of the courts. Now, and again, I'm trying to think of some examples. So I'll think of the one that, very unfortunately, I have gone through and looked at, which is the Transport and Other Road Users Management Act. So the Queensland Parliament passed a big statute which says we give the power for other bodies to pass delegated instruments where they can fine people for doing stuff. Parking regulations. We say in this Act, we give power to a list of bodies, and one of those includes the Townsville City Council, to pass regulations and gazetteer those things. Gazetteer, T-A-Z-E, gazette, double T-E-E-R, I think that's how you spell it. It's a term that means to publish those things. And those rules have actually changed, by the way. They've changed in 2017, the rules for gazetteering in Queensland. The idea is that when the council wants to allocate an area, a defined area where they can fine you, they have to publish that. It used to be they had to publish it in a thing called the Government Gazette, and so those bylaws weren't going to be valid until they were published in the Gazette, in theory. I'll come back to that, specific rules for that. These days, they can just publish it on their website since 2017. And so the gazetteering requirement used to be a thing. It's not really much of a thing now. But you'll still have to look at it in regards to your assessment for the subject. So, one of the things to note, though, is that the High-Level Act, in this case the Transport and Other Road Users Management Act, says these bodies can allocate areas for them to both fine people and collect that revenue, and the maximum penalty that they can have for parking is something like, I think it was something absurd, it's like 100 penalty units. So the most that you can pay as a fine under the Act, or instruments under the Act that have been validly passed, is $13,000. Now, as you could imagine, you'd be quite outraged if you got a $13,000 fine, and so what the council does is that they will carefully go through and map out the areas in which they're going to find stuff. You know, this particular spot, they will do it by the spot or the particular street from this point to that point. And they'll allocate those things, give them appropriate signage, publish that stuff on their website, and list what the fine or maximum fine is going to be. Again, usually in terms of penalty units, and usually they round down to something like the nearest $5. And that's how it works. That's how their power works. That's how the power works. So that they, parking in the CBD, what's a fine these days? $35 for exceeding? I think it's 35. which is half, by the way. I don't know if you guys are aware of this. They're actually half what they are supposed to charge. They do that for what reason? Why do they only fine you half what they're allowed to? What's a practical reason for doing that? Is that any idea? So you pay it on time. You pay it within 28 days. You pay half the amount. If you don't, you pay the full amount. And Simon took umbrage with this and decided to go and challenge the limits of their power. And I won't name names in terms of the magistrate. Magistrate wasn't reading my submissions. That was an expensive day. Anyway, that's for a story for another day. But talking about Shanahan and Scott. Shanahan and Scott involved the Victorian Egg Board, which had been founded and created by a statutory regime. Strictly speaking, it wasn't the Egg Board, it was the Egg Marketing Board. And so the Egg Marketing Board created some regulations to do with the transport, storage, and destruction of eggs. Transport, storage, and destruction. All right, what do you think the problem with that? Just in the very, very brief summary of facts that I've given you there, what do you think the problem might have been there? The statute created an egg marketing board, and they purported under the regulation to give powers to transport, store, and destroy eggs that were somehow beyond a certain age. The point of the statute was to do marketing. There's nothing to do with the health and safety aspect of looking after eggs. There's nothing to do with it. And so that's sort of the starting point that we use for this. It did go to the High Court too. Starting point for looking at this, when you're looking at a regulation, so an instrument which is created by an executive decision maker under an enactment, that it has to align with the statute itself. And there was no logical connection between that. The whole point of the statute was to create a monopsony, single buyer, in order to market eggs across all of Victoria elsewhere, other states and other countries. That was the whole point of that statute. That board's job was to market stuff, was nothing to do with the regulating of health and safety concerns. That's just fundamentally not what the purpose of that was. This regulation to destroy eggs wasn't tending to achieve the objectives of the governing statute. And so when we're looking at statutes, we often underplay the little bit at the top that has the purpose of the act. It's really important in this area of law when you're going through and looking at stuff. Now, an interesting one I've noticed, I've gone just recently and read the James Cook University statute. All right, and who went to the Legathon? I know Maddie did. Anyone else do the Legathon? No? Okay. We're probably not going to run it next year, but it's the year after next, if you guys are still around. I do recommend doing that. And I did a god-awful interview on law of the tropics. Why is this a thing? And everybody, the academics, are like, this is just rubbish. I'm like, well, it might be rubbish, but it's in the James Cook University Act as one of the objectives. So the fact that you think it's rubbish, that's nice and all, but it's part of your job, because the things that you do flow from the power that's given to you under that act, and that is one of the objectives of that act. And so I don't mind saying it's rubbish. Sure, it's rubbish. It's still part and parcel of the objects of this particular university, and only this university. Oh, maybe Charles Darwin has it as well, I'm not sure. But it's not just a marketing twist. It's part of the legislative framework, and you guys studying administrative law. And so you guys know that stuff that gets passed under that, again by the council these days. JCU, in fact, a bunch of universities in Queensland Parliament has actually just changed their governance structures, removed university statutes, which was the delegated instruments. They've just removed that. Now you have council. The council is the body that will go and pass essentially regulations directly. So they don't need to go signed off by the governor and don't need to be published. Go through a series of quite rigorous rules to do that. But they're still going to make decisions in accordance with the objectives of the Act itself, including parking. Okay, following Padley, that's the Hare Krishna case. And I have the quote from this Hare Krishna case. Who's been to Adelaide? Anyone else been to Adelaide? I mean, not missing much, to be honest. It's sweet. Everyone's well dressed, but it's a little bit boring. It's kind of like a flat, stretched Townsville. It's much colder, and and other things that aren't going to go on the recording. But anyway, there's a place in the middle of Adelaide called Rundle Street. It's like their mall. It's basically kind of like what Flinders Street was between 1978 and what do I change, about 5, 6, 7 years ago, when they put the road back in. Why? Because they realised that it didn't work, which is quite a remarkable thing for a council to actually acknowledge. They did this great world-leading thing to have this pedestrian mall. It was going to be awesome. Turns out it wasn't, and they've realised that and changed it back. And now it's actually quite nice. And probably not bringing business back to the CBD, but at least they're trying. Anyway, Rundle Street is the equivalent of what that pedestrian mall was like in the middle of Adelaide. And the South Australian Parliament, when they were setting this thing up, it was all a rage in the 70s, passed the Rundle Street Mall Act, 1975. And the empowering section, regulation, said that the council can make bylaws regulating, controlling, or prohibiting any activity in the mall that is, in the opinion of the council, likely to affect the use or enjoyment of the mall. Say that again. Regulating, controlling, or prohibiting any activity in the mall, in the opinion of the council, is likely to affect the use or enjoyment of the mall. It's pretty broad, eh? The only thing really limiting this, and from a cursory read of this, is the fact that it involves the mall itself. So anyway, the bylaw that was passed said, no person shall give out or distribute anything in the mall to any bystander or passerby without permission of the council. And so you had the Hare Krishna organisations were there, wandering along, giving out pamphlets to people. Become vegetarian, or whatever they said. And went all the way to the High Court. And the council won. Hare Krishna's lost, although it was a split decision. And while essentially it was done in sort of technical grounds, they looked at, and this is from the majority, it was sufficient to inquire whether the activity described in the bylaw could reasonably have been regarded, and this is using an objective test, so a reasonable person would have thought that it was likely to affect the use and enjoyment of the mall. So that, in statute it said use and enjoyment of the mall, and the power in the bylaw was conditional on an opinion. So we've got a bit of a problem there, of course. What was that opinion? So they said, look, opinion has to be reasonably held. That's the first thing to come from that. And they also looked at when we're looking at this power, in terms of the importance of it. And this is Chief Justice Gibbs, and he makes he actually makes the point about these types of regulations, that when you're going through and doing and stopping the enjoyment of stuff, this idea of needing to have civil and religious freedoms isn't actually as important as the need for the council to go through and regulate and keep things tidy. So this is kind of, you guys are aware that a case from a JC law student went to the High Court, Pat Coleman, Went to the High Court when he was on Townsville's pedestrian mall giving out leaflets. Went to the High Court. Turns out you're not allowed to assault police after this. Sorry, Pat. But you are allowed, within the implied freedom of political communication, to give out pamphlets bad-mouthing police officers. And so that was what they were talking about there. And so Chief Justice Gibbs said that the question of the court is simply whether the council could reasonably have formed the opinion the activity is likely to affect the use or enjoyment of the mall. So this thing went all the way to the High Court, and they basically just affirmed the fact that this can be done. You can go through and regulate and stop people from doing things, even in situations where the governing statute is a little bit vague and it gives what looks like an open-ended amount of power, so that it is in the opinion of council. It looks like an open-ended power. No, it's not. You determine that objectively. It's not a subjective test, it's an objective test. But that's otherwise going to be fine. Okay, and again, I'll talk about the broad ultra vires stuff because we look at this proportionality. I'm not sure why that's in there actually. But look at any particular delegated instrument. You have to look at whether what's been put there is reasonably proportionate. And usually here we're thinking about dollars. Again, those who've done constitutional law will be aware that you can't just pass regulations and say, oh yeah, and there's a fee associated with that. So yes, the fee for viewing your development permit is going to be $300,000. No, you can't do that. That's not reasonably proportionate to the amount of cost it actually puts the council. And we'll go through and examine some of those. Anyway, regulation. And they make this distinction, by the way, between regulating and prohibiting. This idea of that you can take control of an area under statute. Statute will say, Townsville Council can make bylaws in regards to the management of a particular area, but they have to be careful about that, because when you use the word regulation, Parliament said this stat body, again, most of these things involve councils. When you see the term corporation, Melbourne Corporation, Swan Hill Corporation, that was actually the original name for the relevant council. We use the term councils in that place. So these old cases, you'll hear about the Melbourne Corporation principle, for example, in constitutional law. It's the Melbourne City Council. But anyway, Melbourne Corporation and Barry was to do with veterans, essentially. Veterans going on parades, so World War I veterans in that case. And whether or not the council could prohibit them from having a parade. The council was given power to regulate, and that does not give them the power to blanketly prohibit stuff. So powers to regulate do not give the executive decision maker the raw power to prohibit things. That's the starting point with that. And so, again, they wanted to have a parade, and the council said, nah, we have the power to regulate whether you can have parades or not, and we're saying no. And so it went to, I'm not sure whether it went to the High Court or the Privy Council, but nonetheless, and they said, council doesn't have power to stop this from happening, only to regulate how it happens. That's Swan Hill? Yes, Swan Hill's the next one. Swan Hill's to do with regulating buildings. Again, went to the High Court and buildings. So the relevant instrument talked about the idea of restraining. And so there it was Chief Justice Latham said that restraining people from putting up buildings is not the same as suppressing or prohibiting. In that when you are regulating stuff, you are guiding, you are not stopping. It's a fundamental nature of the concept of regulation. We don't stop citizens from doing things, but we can sort of push them in the right direction in order to keep society organized. We're not trying to control society, we're trying to organize it. Fundamentally, it's about good governance. We want people to do stuff. The law does not impose duties on citizens. That is the language of feudalism. Give people rights to go through and do things. All we are saying is that in order to regulate stuff, you want to have a building? Sure. You're going to have to jump through these hoops to do it. You're going to have to do all of these construction works. You have to get all of these permits. You have to give us all of the plans. You have to pay a fee. That fee can't be exorbitant. The fee can't be a revenue-raising exercise, but it can cover the cost of regulating all of those functions, which can include overhead, the council's overhead as well. Okay, and the Gold Coast CC bylaws, I'm not sure if that's the same case, but again, I think it was that case, was the one that involved street vendors on the main strip in the Gold Coast who were prohibited from trading on the verge, on the footpath area like that. You know, when you go to Lygon Street in Melbourne, who's been to Lygon Street? All of these analogies don't work very well. Young people, you need to travel. When you go to Melbourne, go to a place called Lygon Street. It's awesome. It's like a restaurant strip. It's got all these Italian restaurants and all sorts of other restaurants. It's really, really good. One thing that you do notice when you're walking down there, you see it a little bit in Townsville as well, where you've got the footpath and the road, and the seats are on this side. Actually, Cairn CBD has this as well. Those have been the Cairn CBD, where you're walking through, and the seats are on this side, and then there's the road. All right. This, by the way, is, to me anyway, it's a very Australian-y sort of a thing. It doesn't happen so much in New Zealand. That's because Kiwis are really terrible drivers. That would just end up, would just work out really badly. And what, in this particular part of the Gold Coast, they passed regulations that said we are not allowing people to do any sort of trading. And the court went through and looked at this and said, look, what you've written in terms of this regulation is stupid. You would stop kids from being able to trade, cards. You used to have little cards. They used to trading cards. You would actually prohibit that. You're prohibiting all forms of commerce and non-commerce aspects of doing things, swapping things, trading things on there. It's gone way too far. It's gone absolutely way too far, way beyond regulation in relation to that. To essentially, even though you're using the term regulation, really, in substance, it's a prohibition. It's a prohibition, and we're not. That is not the purpose of regulation. If you want to prohibit stuff, what do we do?
Sorry, just to ask.
Yep.
That also affected the issue around the meter maids, or whether they took the coins in the anymore.
Meter maids.
Is that the same one?
This one didn't involve the meter maids, but the power to create, manage, and use meter maids comes under the Transport Act. And that, because that's expressly mapped out in Parliament, they have very particular rules about, in the Act itself, about how and where the systems, well, these days, it used to have things specifically for those machines with coins, and that was carefully mapped out in the statute itself. By coincidence, I happen to have read this. These days, they've moved it to a broad term, which says a recognised or authorised system, which is things like the pay and display, like that. And so that authorised system sits in the Act, but I have to admit that it's in the regulations where they define and describe it. So you could make an argument that counts as commercial, but you'd have a hard time because councils aren't in trade and commerce. They don't pass that business sort of test. But certainly with this one here, the council wasn't intending to include themselves as part of this. They never do. And to just make note, a lot of your tute questions from this point forward will be on this area, even though I haven't spent a lot of time on it. This idea of regulating as opposed to prohibiting is something that comes up. And I think if I carried on with the subject, I'm probably not going to teach it again next year. If I carried on with it, I'd probably start to include examining the statutes, particularly the James Cook University statute. Because with this newfound power that you guys have, your new superpowers, you can go through the JCU Act and work out what it is that they're doing. And sometimes looking at where they've exceeded that power. All right, now I'm going to look at procedures. Okay, so procedures are things that are put in place for executive decision makers to do. They must do this and this and this as part of, say, reaching a particular decision or achieving a particular result. Procedures that must be followed, or may be followed, or ought to be followed. And it is not uncommon for the procedures to not be followed to the letter of the law. And so the example here is that AAT decisions must be given to the people involved. So as the AAT have to be gone and published. This obviously makes perfect sense. That's a procedure, it needs to be followed. But it also says specifically in the AAT Act, if this is not complied with, the decision is not invalid. The Parliament's already mapped that one out. It said what's going to happen. So that would be really, really easy if everything's all mapped out like that. But invariably it's not. Invariably, instruments, both primary and delegated, will have series of steps that the decision maker is supposed to go through. And we, as administrative lawyers, have got to work out whether or not near enough is actually good enough. That's fundamentally what this thing's about. Is substantial compliance, and these aren't my words, these are the words of, have I got it? Again, I think it was, I thought it was Gibbs, but it's not Gibbs. Not Gibbs and Skur. I don't have the, it is a High Court case, but I don't have the actual judge, where they talked about this distinction between substantial compliance, pretty much doing it, and not quite getting there. You've got these procedures, substantial compliance, is that going to be okay? In some situations, near enough is going to be good enough. In other situations, it's not. Okay, so SCUR is to do with development applications for council, Brisbane City Council, and not giving the proper notice steps is a condition is going to cause the thing to be invalid. Giving notice is a condition precedent to actually performing the thing. You needed to give notice in order to move to that next step. Because Parliament's clear intent when passing planning statutes is for people to get involved, people to know about development decisions that are going to impact them. And so the system, the careful system of giving notice and publishing things in certain places, giving people the opportunity to find out about it, is a core function. And as such, strict compliance is required. And so that's Hunter. Who do you have Hunter? Hunter Resources is a mining tenement case. Do you guys know what a tenement is? Tenement is a plot of land. It doesn't have to align with particular owners. It's just an allocated plot of land where, as a mining exploration entity, you can wander up to and drill holes to see what's in there. My ex-partner of many, many years is an exploration geologist, and if she could ever hear this, she would probably be cringing right now at my horrible explanation of mining tenements. And what they said in Hunter Resources in Melville was strict compliance with the tenement rules, which require you to peg your tenement. Actually put pegs in the ground to map out how and where it is, actually is very important, because others are wanting to come along and peg things, maybe nearby. Maybe they want to do some drilling. Farmers need to know which bits are going to get drilled and which bits aren't going to be drilled. Claimants in native title need to know how and where things work. And so as such, strict compliance, putting the pegs in the right spot, is going to be, well, they say mandatory. Strict requirements is required when mapping out your tenement, because a lot of other people are involved, including your competitors. They need to know where your bit finishes and their bit starts. Watson and Lee, this will come up, this is a reasonably important one, where, and also this is something that has to be re-examined after the 2017 changes in administrative law. It's one of those bits where I actually have to trot along and have a little look, because Watson and Lee said, look, gazetteering, which is the process of publishing your delegated legislation, usually this would be a precondition, but, and again, I think it's Justice Mason, my favourite judge, says, look, no one reads these things. No citizen goes and reads the local government gazette to determine whether or not the council's changed the amounts of their parking or changed the regions, whatever. Nobody does that in practice. And as such, this idea of needing to go through and publish these things strictly, and so much so that there's the requirement being so much so that if you don't publish it, it's going to be ultra vires, that's a little bit silly. It really is a bit silly. The idea, things that no one's ever going to read actually are somehow going to render the decision invalid is a bit dumb. And so there they talked about this distinction between mandatory and directory, and they said, look, it's not really a hard and fast rule. It really depends on the circumstances of the particular matter that they're dealing with, and particularly the gravity of it. And the courts say that, look, this distinction, this hard and fast distinction between mandatory and directory, it actually depends on both. It's not just going to be a strict question of law as to whether it's one way or the other. Okay, Project Blue Sky. Good old Project Blue Sky. That was a case involving, I think it's the ABC? Yeah, Australian Broadcast Authority. Why? Because the Australian government mandated that a certain fraction of TV shows had to be Australian, right? Seems reasonable. It seems like a reasonable policy sort of objective. Fine. They've done that, to put it in the statute. And the Australian government also signed up to the Trans-Tasman Agreement that says trade between New Zealand and Australia, subject to strictly necessary regulation, shall be free. Again, seems reasonable. One of these countries has much lower wages than the other. One of those countries can produce television shows at a much cheaper price than the other one of those countries. And so this went up to the High Court to argue the fact that, look, when you're going and determining, in this case they had to go through and look at those particular regulations that had been passed to see whether or not it actually fitted with those two legislative frameworks. It's going through and looking at that. And they went and looked at these older High Court cases where they talked about this distinction between directory and mandatory. And they said that, look, it's not very helpful. And in line with a lot of this sort of I guess, the shift in legal culture or convention, the zeitgeist, this push in the last 50 odd years towards drawing judicial interpretation from the will of Parliament. The purpose of approach and stat interpretation, for example. We go and look at the statute, the enabling statute, to see whether or not strict compliance to procedures is going to be required. That's the thing you want to be doing. It's not going to be a strict legal definition where we look at a particular regulation to try and determine whether it's mandatory or directory. We can't do that. It has to be much more fluid, and it always must flow from the purposes of the Act itself. So the Act is going to have enabling sections. Those must always be read in the context of the objectives of the enabling statute. When you're looking at those two things, then you go and look at the delegated instrument to try and work out whether the procedures that have been mapped out need to be followed or not. Or, if the procedures are in the Act itself, those procedures have to be read in relation to the objectives of the Act itself. Does it kind of make sense? It's not particularly riveting stuff, don't get me wrong. There's much, much more exciting things that we could be, other subjects we could be doing, but I'm sure after most of you 3 years of law school, you're sufficiently comfortable with a little bit of boredom. Okay, and a wall of text on the screen, which I try not to do actually. But you'll be pleased to know this. Was almost the last slide. Oddly, I talked about Somerset's case in contract law yesterday. We're going to go over it again. And so this is some things to know, because I made the point for you guys about statutory interpretation in administrative law kind of sitting slightly differently to how it does when you're ordinarily reading a statute. And so my contract law class for their second assignment is doing a stat interpretation task. They're having to go through and read the Australian Consumer Law. And they're using all of the principles of stat interpretation that you would have got from LA3006, legal research and writing. Doing stat interpretation, really, really important. It's the single biggest problem that the profession comes back and, whinge is probably not the right word, wraps the knuckles of the universities for not encouraging us and not making students do this. I put a lot of effort this year into redoing the trust account subject to make it essentially an exercise in stat interpretation rather than a mechanical writing of checks. I don't think they appreciated that very much, but that's our job. And one of the things you guys may or may not know about stat interpretation is how to do it. What are the steps? So you start in any given section, any given word, any given term, to read it, and you have to read it in the context of the sentence that it's in. You have to read it in light of any modifications that has been made in that same section, or in the division, or in the part, or in the chapter, or in the act, or in other acts. And so the example I had from, and again I'm going to use examples from contract law, was in the Australian Consumer Law. A person in trade and commerce must not engage in conduct which is unconscionable within the meaning of the unwritten law. Section 20 of the ACL. And so you had to go through and look at the word person. Person seems like a pretty straightforward sort of a word. Is it defined somewhere else? Well, kind of. It's modified elsewhere. And so it's modified in that particular part of the ACL to include a partnership. As we know, partnership's not actually a legal person. It's just a bunch of people, or natural or otherwise, coming together with a view to run a business together with a view for a profit. Not a legal person, but that particular section adds that onto it. And the Acts Interpretations Act also takes the word person and adds something else onto it. What do they add? The fact that body corporates, corporations, incorporated bodies, body politics, they all count as persons as well. So that particular word that they're interpreting has to be read in the context of the section, the division, the part, the chapter, the act, definitions in the act, definitions in the other act. And make it even better than that, in the common law as well. From time to time you'll have words which are defined in the common law. And so when we say the starting point is to look at the ordinary natural meaning of a word, which can be confirmed by a dictionary. This is how you do stat interpretation. This should be familiar to you guys. For some reason, it wasn't familiar to the first years, and they've done LA112 much more recently than you guys have. So that you guys know exactly what I'm talking about, right? Because you do this every day. Yeah. Getting those looks. And when there's two or more possible interpretations of a particular section, which one is to be preferred? Blank looks everywhere. It's the one which best achieves the purpose of the legislation. Why is that? Because Parliament says so in the Acts Interpretations Act. They put that in as a rule. When there's more than one interpretation, pick the one best to achieve the Act's intention. And they even say, all of those common law presumptions that you have, all those presumptions, well, we're not saying they're gumph, but you only go through and use those common law presumptions. You guys know what I mean by the common law presumptions, the idea that Parliament doesn't intend to take away fundamental rights, that you construe criminal statutes in favour of the accused, that you construe taxation statutes in favour of the taxpayer. You presume that any particular statute is not designed to undermine Australia's relation with foreign nations. There's a variety of them. And in ordinary statutory interpretation, they are the last chance salon. If you've gone through all those other steps and you still can't pick which of those aligns with the purpose of legislation, then you use those. Now, it's not actually how things work in admin law here. We're trying to ascertain the purpose of the Act, because we're looking at what the purpose of the Act is when we're going through and looking at stuff. And so it's almost like we're jumping through a few, we're elevating these statutory presumptions further up. They get analysed further up in this process when we are trying to determine what Parliament's intent. We are going through and looking at the common law presumptions, because when we're interpreting Parliament's intent, we will presume all of those common law presumptions have been used in coming to this particular result. And so, these cases, Somerset's case is actually to do with slavery, and it refers to an earlier case in the 1500s. So Somerset's case is in the 1700s. That was to do with a black slave, a Jamaican, who was taken back to the United Kingdom and escaped and was recaptured, and what do they call them? An abolitionist sought and obtained a writ of habeas corpus. What's the writ of habeas corpus? Bring the body before the court. And there, they referred back to an earlier case called Cartwright's case. Cartwright's case is from the 1500s and referred to a white slave. And so you had an earlier case, white slave, which was the guy was like Romanian or Russian or something. There, the phrase that was used back in the 1500s was, "The air of England is too sweet for a slave to breathe." And that was reiterated in the 1700s and said, yes, that actually applies to all people, not just white people. And so that, there was a 200-year gap between those two cases. But essentially, from that point in the common law, slavery was unlawful. 1772. Still pretty late in the piece. But the common law from that point. So you'll note with that year, what year was the First Fleet? Everyone who's not Ewan should all know this. What year was the First Fleet? Kayla? First Fleet, 1788. And the First Fleet comes, brings the common law of England, or United Kingdom, Great Britain at that stage, and British common law arrives in 1788, which means that rule was already there. So slavery has never been a part of the Australian common law. Okay. Coco and the Queen was to do with listening devices. And those listening devices were obtained without a warrant. They were trying to work out whether or not executive decision, essentially the police, federal police, can go through and do that. they had to go back and look at the statute that gave them the power, and they said that, look, you can do things like this, provided Parliament has been crystal clear in giving you the power to override the personal freedoms of citizens. Parliament must be crystal clear in relation to this. Re Bolton ex parte Bean is another stat interpretation case. I love this case. This lecture has all of the funny ones. So this guy was an American. Mr. Bean was an American, and he had gone, and it was a serviceman, and he deserted. All right, so during the Vietnam War, he deserted the American military. All right, moved to Australia, and some time later, like in the mid-80s, I think it was at a pub, and some of his former servicemen saw him. So a bunch of visiting American troops saw him. Their eyes would have opened wide because they recognized who he was from 15 years before, picked him up, put him in the brig of their vessel. All right, so again, writ of habeas corpus, get him out for the court. And they had to go through the relevant statute. And it says it is actually a crime for a person to desert from a visiting force. It's a crime to desert from a visiting force. All right? What's the problem with that? What's the problem with that sentence that I just said? Desert from a visiting force. Heard?
Signed by those forces who come to Australia.
Yeah, well, kind of. You kind of, yeah.
The visiting forces act actually applies to Australian servicemen.
Yeah.
Unless they sign off.
That is. Although this was an older statute. This goes back to days. It got changed a little while after. The difficulty there was, because we're talking about statutory interpretation here, did he desert from the visiting force there? Or did he, because he deserted in the 70s, somewhere else. He didn't desert from the visiting force who picked him up and put him in the brig. He'd deserted from the same body a long, long, long time ago. So when you're going through and you're appreciating there's ambiguity in this, because the word desert is a verb. You are a deserter, you desert. All right? Does it matter that the time of the visiting is not the same as the time of the deserting? Bit of ambiguity there. If you're going to lock somebody up, and because deserting's got a pretty big penalty, if you're going to lock someone up, take away their fundamental rights and freedoms, you make crystal clear that stuff. And so what they did is they actually went back to work out the intention of that piece of legislation. Now you appreciate that piece of legislation was passed at the height of the Vietnam War, and you've got, in no uncertain terms, the speech of the minister at the time saying, "We will shed blood on the same soil as our American brothers." That's been expressed in very, very, very strong language, the speeches of the minister. In fact, the case you guys may have come up in L1 too, because that is the case example where you can't impute the will of Parliament as the speech of the minister. That those are two different and distinct things, which is why when you're trying to interpret the will of Parliament, you may use extrinsic materials. Right? The court may take into account the speech of the minister, but that is optional. If you can impute the will of Parliament without recourse to that, you do that first. So that's the sort of situation, though, as an example of ambiguity. The parliamentary draftspeople didn't think about that at the time. Deserting from a visiting force, it's straightforward. Everyone knows what that means. Didn't occur to them that the deserting and the visiting could be separated by 15 years. That was the difficulty there. So, okay. And, is this good old Justice? No, that's not Justice Mason. This is back in Project Blue Sky. This is the last slide as well. Okay. And I wouldn't say they went AWOL. They kind of departed a little bit from a very strict legalist approach to this. And they said that, look, from time to time, the actual words themselves aren't going to align very well with the objective intention of Parliament. So particular words in a sentence, again, deserting from a visiting force. the strict grammatical reading of that really just doesn't work. It's not going to work in that situation. And so we have to actually go back and read other parts of the Act in order to determine fundamentally what Parliament was trying to do. The instrument that we're given is the Act, and from the very first word to the very last word in the Federal Acts Interpretation Act forms part of the Act. This is the thing we're working with. This is the thing we're going to use to try and do that. And look, part of determining the purpose of Act is looking at other sections. What are other sections trying to do? Are they trying to regulate? Are they trying to criminalise? Are they trying to, literally, to prohibit? Are they trying to stop certain types of behaviour? What is the statute fundamentally designed to do? What is its what is its purpose? Teleologically, what is its design? And so that, and I believe that's the last slide for this lecture. When we are going through and doing this sort of interpretation of the statutory provisions that you're given, and in the context of your broader life, when you are going through and looking at statutes, that you can look at the thing in entirety to try and determine what that is. When you're looking at a statute, you're reading a particular section, and you can look at other sections that relate to that, and other acts that interact and modify those words. But this is the starting point. And you're trying to determine Parliament's intent. That's the starting point. Don't rush into reading other material, because courts will not rush into reading other material. We presume when Parliament passes legislative instruments that these words enshrine their intention. It's a really important consideration, because that idea, you can go and look at the speeches of the minister like they did in Spider-Man. You can go and try and determine, the aim of this is clearly to achieve this message. Well, start with what's in front of you, but you can start with the whole instrument. That's really what they're trying to get at there. That you'll have the objects at the top, the objects of the act to do this, that, and the other thing. That can be interpreted in light of how that's been manifested in the whole instrument itself. And so I'm going to leave that with you guys, because this is something of a refresher and stuff that you would have learned out of 1 or 2, but you'll do your legal research and writing subject right at the start of your degree. And this is a case of going through and revisiting that. And you've got to pay this more than just lip service. You are going to have to go through, and I do recommend you do, and re-examine this stuff. Particularly for those doing contract, because you're having to re-examine it in the context of actually doing a stat interpretation problem. But just make note that there's slightly different here, because we are determining the purpose of an act. It's a fundamental part of doing this particular task when we're looking at whether things are followed particular procedures, whether those things are important or not. We are needing to determine the objective of the act, and so we're using all these common law presumptions as part of it. We don't do that when we're doing an ordinary statutory interpretation part. Why? Because that step comes later if there are multiple possible definitions. Actually, they happen at different parts of the stat interpretation process. I'm going to go through and explain that again. Clear as mud? Yeah, good. That expression says it all. When you're doing stat interpretation, and again, going through the Australian Consumer Law, reading something like that, you go through and look at the ordinary meaning of a word as modified by other parts and other statutes. We go through and determine this. If it is clear from those words, in the context of the statute, that this only has one possible meaning, that's the meaning that it is. If there are multiple possible meanings, we pick the one which is closer in alignment with the purpose. Okay? So that's essentially, it's a secondary step that we have to go through and do. And if we still can't do that, then we go through and look at the fundamental, these common law presumptions. When we're doing this statutory interpretation as part of administrative law, when we're trying to determine whether a particular series of procedural steps requires it to be followed to the strict letter of the law or not, we will go through and look to the purpose of the act. So it's kind of like we're interpreting this, but we're trying to look at the purpose of it to see whether or not strict compliance is required. And so when we are going through as part of this, looking at the purpose, we will actually go through and throw those common law presumptions in there to try and determine what the Parliament's intent is. That's things that we will and can throw in as part of that process. So that process is slightly different and distinct. We're not trying to find multiple possible ways of interpreting this and then picking the one that aligns with purpose. We are fundamentally looking at a factual situation where these procedures haven't been followed, and we need to determine the purpose every time we're examining these things. And we do that by appealing to Parliament's good nature in not trying to remove stuff, because there's already going to be, we know there's going to be ambiguity. There's one possible situation that we're looking at, and we need to determine, using those presumptions, how to resolve this. That's how that sits. I'm going to go over that. I think I'm going to go over that again in the shoots, I think. So that could probably, that could be a whole lecture on its own, that stuff. But, okay, I'll leave you guys there anyway.